Good afternoon and welcome back. I'm Marcus Peter. As I mentioned in the open earlier, the U.S. Supreme Court said a New Jersey faith-based pregnancy center may challenge a state subpoena demanding donor information. My friend Andrea Picciotti-Bayer joins us with more. Andrea is legal analyst for EWTN News, and she is the director of the Conscience Project. Follow her work at conscience-project.org. Andrea, as usual, thank you very much for joining us.
Marcus, thanks for having me on. It's great to be with you.
Always great to speak with you. You and I have been following this piece for a while now. In the interest of our listeners, let's refresh their memory of what's going on in this case.
Yeah, this is really interesting, Marcus. Back in 2022, the New Jersey Attorney General Matthew Platkin created what he called the Reproductive Rights Strike Force that was dedicated to protecting the abortion industry's monopoly on the narrative around pregnancy. And that strike force targeted specifically pro-life pregnancy centers in the state, including First Choice, which has been operating since 1985. It's a Christian pro-life pregnancy center, and basically making allegations without any complaints that had been filed with the Attorney General's office that there was misleading, that First Choice was misleading its donors, misleading the women that went to it for support, and basically issued what it was called an administrative subpoena for documents related to all of the operations of the ministry, including the identity of anyone that made donations to the center. Now that should be, crazy enough. But when the center said that, hey, this is interfering with our constitutional rights to association by demanding that we hand over the identity of our donors, the state said, no, you can't go to federal court to make those claims. And the Supreme Court, in a unanimous opinion, Marcus, this is crazy, said, no, yes, they can. They can go to federal court because they have stated not only an injury that's happening because these subpoenas have been issued, but also one that could, be aggravated if First Choice turned over the identity of donors, because it would definitely chill people. It would chill their support for First Choice. And so the case is alive and kicking, and hopefully the new New Jersey Attorney General is going to back down and kind of give up this thuggery against this pro-life center in the state.
Did the Supreme Court decide on whether the New Jersey investigation was lawful on its merits against this pregnancy center?
Marcus, that's a great question. It didn't yet. It sent it back to the lower courts to evaluate the merits. But the challenge is, and this was something that the district court and the state had said, is that First Choice didn't even have the right to get in to federal court, that they didn't have what we call standing because they hadn't shown an injury, in fact. And that's one of those elements to go to federal court, is there's got to be something that can be resolved by the courts. You can't just go to a court for an advisory opinion. You can't go to court if you're just upset with something. It has to be something that creates an actionable remedy for the court to resolve. And the Supreme Court said, hey, there is definitely an ongoing injury to these First Amendment associational rights, and so they get into federal court to make their claim. And it's pretty sure that if this case comes up on its merits to the Supreme Court, there's a very friendly court waiting for First Choice. If that comes to it, hopefully it won't, because, again, defending these suits is just distracting First Choice from what they're set up to do, which is to help women in need.
The last time you spoke about this case, you also highlighted the question of ripeness and First Amendment associational rights. Can you please enlighten us as to how that plays into this phase of the case?
These are all about whether or not a party can go into a case, or you have to wait for an injury. What was interesting in the Supreme Court's treatment of it this morning was they said that there's an injury that may happen in the future. People are going to not want to make donations, but there's already an injury, and they pointed to a testimony from a number of anonymous donors saying that they are anxious about their donation. They're worried about their donation being made public, that their identity being made public, and they're concerned about whether they want to continue to support First Choice, which is, again, another reflection of how antagonistic people who are pro-abortion are against those of us that are supporting alternatives to abortion for women in need.
How does Article 3 of the First Amendment play into this?
It's Article 3 of the Constitution, and again, it's, just about the judges of our federal courts can't step in unless there's a case or a controversy that they can resolve, right? They're not able to kind of opine on something. They have to have a live controversy that their ruling can resolve and hopefully give the plaintiff, in this case, some sort of remedy. In this case, we already see that there's a remedy here by saying that just issuing a subpoena itself causes an injury to people that are supporting First Choice and to First Choice itself, because there's a question mark on whether people are going to continue to donate or will donate in the future. And what was really, really fascinating about this is we've gotten so used to issues related to abortion being, with very different camps. But in this instance, a number of progressive groups, including the ACLU, filed briefs in support of First Choice because they too know that when the authority of the state is used to disclose the identity of their donors, it could impact negatively their organization, both the money that they receive, but also the support that they receive. And so it was a banner win, not just for the pro-life pregnancy center, but for First Amendment rights in general. Those rights are associational as well as the core rights attached to them. And that was something that the Supreme Court made clearly, that, our right to free speech is a right to communicate with one another. So there's an associational element to all of the First Amendment rights, and that right itself can be vindicated even before a subpoena has been issued or enforced. But just the fact that it's been issued and announced is enough to cause a harm to those rights.
Could you also share how a case like this, a situation like this, doesn't just put the pregnancy center or religious-based pregnancy centers at harm, it also makes the donors individually vulnerable as well?
And it does in part because so many people that are, sadly, to say, pro-abortion are kind of crazy, and they really go after people that want alternatives to abortion to be available to women who are experiencing a pregnancy without the natural support. So we know, just think about the Supreme Court justices themselves that ruled in favor of or ruled against Roe versus Wade in the Dobbs decision. They've had their homes picketed. Justice Kavanaugh had an attempted assassination on his life. A man came to his home with, intending to harm him, to kill him, and other people that have been strong pro-life advocates have had threats levied against them. And so this is a good reminder that, the danger in supporting life often is your own life. And the Supreme Court recognizes that and recognizes the right to be anonymous if you want to in support of righteous organizations that are helping women.
Andrea, as usual, thank you so much for bringing these cases to our attention.
Marcus, thanks for having me on. Have a great afternoon.
My guest has been Andrea Picciotti-Bayer, legal analyst for EWTN News. We've been talking about the U.S. Supreme Court case about the New Jersey Pregnancy Center. I'm Marcus Peter.